Good afternoon. I'm waiting for a few more people to sign on, and then we'll go ahead and get started. Okay, we're going to go ahead and get started. Good afternoon, and welcome to the Fair Housing and Tenant Selection webinar. This webinar training is made possible in part by a grant from the United Way of Washtenaw County. My name is Kristen Kuran, and I'm the Associate Director of the Fair Housing Center of Southeast and Mid-Michigan. I'm going to give you a brief overview of our work, introduce today's speaker, and then we'll begin the presentation. The Fair Housing Center of Southeast and Mid-Michigan is a private nonprofit organization. Our mission is to end discrimination in housing and public accommodations and to promote accessible, integrated communities. We provide investigative services, advice, advocacy, conciliation, attorney referrals, and community education in 8 Michigan counties. For more information, please visit us online, fhcmichigan.org. Today's webinar is on the HUD guidance regarding tenant selection and criminal background. In 2016, the United States Department of Housing and Urban Development, or HUD, issued new guidance to the real estate community regarding the use of criminal background in evaluating prospective tenants. The guidance explains how using criminal background as a screening tool could violate the Fair Housing Act and suggests standards and procedures that landlords should follow instead. This is the first time HUD has issued guidance on this topic to non-governmental entities. You can find the guidance in the handout panel on the right hand of your screen, as well as other related documents. Our goal for this webinar is to provide landlords with a clearer understanding of what the guideline might mean for them and how it could impact their tenant selection process. Presenting on this topic is guest speaker Elizabeth Owen, Legal Director at the Greater New Orleans Fair Housing Action Center. The Action Center is a private nonprofit civil rights organization established to eradicate housing discrimination in the Greater New Orleans area through education, investigation, and enforcement activities. Ms. Owen directs the center's legal and investigative work and has represented numerous individuals and organizations in litigation against private and governmental entities engaging in discriminatory housing practices. Under her leadership, the Action Center conducted the first fair housing testing audit examining the use of criminal background policies as pretext for housing discrimination. Before joining the Fair Housing Action Center, Ms. Owen clerked at the New Jersey Supreme Court and was an attorney at the law firm of Simpson, Thatcher, and Bartlett in New York. Ms. Owen is a graduate of Wesleyan University and New York University School of Law. During Ms. Owen's presentation, you might have questions. Please submit them in the question panel on the right-hand side of your screen. There will be a Q&A session at the end of the webinar. If your question is not answered today, please expect an email at a later date. Thank you, and I will now turn my screen over to Elizabeth Owen. Just wait one moment, please.
Good afternoon, everybody. I hope you can hear me. Please let us know through the questions if you are having trouble hearing me. Thank you, Kristen. I'm thrilled to have you all participate in this webinar, and I want to thank the Fair Housing Center of Southeast and Mid-Michigan for their leadership on this issue and for inviting me here to speak with you. As Kristen mentioned, I am an attorney, and this webinar is geared more towards housing providers, but I need to give a disclaimer that even though I am an attorney, that this is not intended to be legal advice, and if you are having any specific issues or concerns about your particular tenant selection criteria, I urge you to consult with an attorney to get specific advice on that. I'm going to start today by giving you a big picture overview of the Fair Housing Act. Because I think that, in examining any fair housing issue, having a high-level understanding of the Fair Housing Act's history and purpose makes it easier to appreciate the fair housing implications of that particular issue and criminal background screening procedures in particular. I bet that the housing providers that are participating in this webinar today, those of you who currently consider criminal backgrounds in your screening criteria, my guess is that you do so in part out of a concern for safety. Every housing provider strives to provide a peaceful environment for their tenants. And I think to understand, criminal background selection criteria in the Fair Housing Act, a little bit of a history lesson of how the Fair Housing Act intersects with issues of public safety, and understanding that one of the fundamental purposes of the Act is to ensure a fairer, safer society, will kind of set the framework for thinking about criminal justice background policies. At the core of the Fair Housing Act is, where somebody lives. And, why does where you live matter? Why does access to a particular neighborhood matter? The sad fact is that at least in the United States, where an American child is born is predictive of everything from educational and economic outcomes to life expectancy. So, you think about the neighborhood where you grew up or people you know, and it becomes pretty clear from even personal experiences that where you sleep at night, where you grew up, has determined a lot of the opportunities you've had in your life. I think the most common example that people give are access to schools, but where you live also influences where your employment options are, where transportation is, exposure to crime, whether you breathe clean air, and that has consequences, of course. If you are living in a polluted environment and your child has asthma, for example, are you going to lose work to take them to the doctor? Are they going to suffer in school? And unfortunately, often you can tell just by looking at somebody's neighborhood whether they are going to live a long or short life. And this is a map of New Orleans. I'm going to share with you a map of Detroit later, but I'm from New Orleans, and New Orleans, which has the highest incarceration rate in the country and is high up there in the world, is a great example of how to talk about the impact of criminal background screening policies. But this is a map of New Orleans, and each little dot on this map correlates with a person, and every green dot is an African American, every blue dot is a white person. And you can find these maps for every community just by Googling racial dot map. They're really quite fabulous. But this map right here shows New Orleans, and you can see how segregated New Orleans is. The neighborhoods are either entirely green or entirely blue. And you can tell just by looking at these dots on this map, where people are more likely to die young to have low birth weights and to have health problems, anything running the span from diabetes to sexually transmitted infections. And one can't underscore enough how race plays a role in that. Historically, discrimination has played a role in segregating our communities, of course, but it's also played a part in concentrating the disadvantage in certain neighborhoods. Simply put, there's been less investment, in majority minority communities. Businesses, government, private actors often choose to put their services in these blue neighborhoods and not in these green neighborhoods. And to show how dramatic the effects of place are in New Orleans, those who live in zip code 70214, that's an area that the population is 93% white, practically next door in zip code 70112, where the population is 87% black. You see a 25-year difference in life expectancy. So in the predominantly white neighborhood, people are living on average 80 years. In the predominantly black neighborhood, people are living on average 54 years. And this statistic is based on just where you live. So, in thinking about, why are we here? Why do our neighborhoods look like this? And why is opportunity, as we like to call, access to things like transportation and education and healthy food, et cetera, like why is that concentrated in certain neighborhoods? You have to look back at intentional discrimination and deliberate policy decisions that are created at the local, state, and federal level. I'm showing you here, I think a lot of people have heard of redlining. This is an example of a redlining map of New Orleans. And again, I'll show you one of Detroit, which is probably a more familiar example to you all in a couple of minutes. But you can see here that some of the patterns that you're looking at look very familiar to the map that I just showed you with the dots on it. So redlining happened because prior to the Great Depression, it was very difficult for people to get a loan to buy a home. And the Federal Housing Administration was created in the 30s to make homeownership more affordable to people, and they did that by insuring mortgage loans. In doing so, the government hired folks to create what they called residential security maps of over 230 cities across America to assess the risk of lending in different neighborhoods. And these maps were used, by the FHA in deciding, where they're going to insure their mortgages, and then, private lenders adopted them in deciding where they're going to lend. These maps were influenced by the racial makeup of the neighborhood. So if you look at this map and you see all these red neighborhoods, these were the areas that were considered, D areas. They were graded as D, meaning, we're not going to insure those loans. And in the keys to the maps and in those grades, they were defined as areas where there was detrimental influences in a pronounced degree and an undesirable population or infiltration of it. Basically they're talking about minority populations. There are other government policies that continue these segregated policies and patterns. The GI Bill, for example, guaranteed loans to homes and businesses. And in Mississippi in 1947, for example, there were over 3,000 loans guaranteed by the GI Bill, but only 2 of those 3,000 loans were offered to Black veterans. You can see, other local and federal policies had, led to segregated communities, including, after the schools integrated, there was a lot of white flight to the suburbs. People passed restricted covenants. Those were the concept of individual neighborhoods contracting with one another to keep minorities out of their communities. Of course, the restrictive covenants is an example of how intentional discrimination on the part of private housing providers played a part in the segregated communities, but so did discrimination in the rental market. And that continues today. In New Orleans, for example, we did an audit of neighborhoods that provide the most opportunity, those that are located in what people would quote unquote call the best neighborhoods, to see what is the rate of discrimination by housing providers in those areas. And shockingly, when we sent two testers, one black, one white, both with comparable incomes and backgrounds and equally qualified to rent, 44% of the time, African American testers were denied opportunity to rent in those high opportunity neighborhoods or experience some other kind of differential treatment in the lending process. So what is the effect of all of this? Well, over the years, fair housing advocates like to call this the donut effect, and this example is really pronounced in Detroit, where these segregated patterns have resulted in these predominantly black inner cities, like you see here, surrounded by the white suburbs. And again, this is the effect of decades of policies and practices and prejudices that keep our communities segregated. So what happens when you take opportunity out of these neighborhoods and you concentrate poverty and you segregate your communities? Well, in the 1960s, what happened was significant social unrest. I'm sure many of you have heard of the Chicago Freedom Movement, something that led by Dr. Martin Luther King Jr. And they did the first test, actually, interestingly, where they used black and white couples with the exact same income, and kind of tested real estate agents to find racial discrimination. But the Chicago Freedom Movement, put on these large marches through all white neighborhoods, and in the 60s, there was significant racial violence against them. And this kind of social unrest was happening across the country. And so President Lyndon Johnson established the National Advisory Committee on Civil Disorders, which is called the Kerner Commission. And it identified residential segregation and unequal housing and economic conditions in the inner cities as significant underlying causes of the social unrest and disruption that was happening. They found that both open and covert racial discrimination prevented black families from obtaining better housing and moving to integrated communities. And they kind of concluded that, this was in a crisis here, and that was moving towards, I'm going to quote, two societies, one black, one white, separate and unequal. As a result of the Kerner Commission, they recommended that the Fair Housing Act be enacted in order to reverse what they called a deepening racial division. On April 4th, 1968, of course, Dr. Martin Luther King was assassinated, and this is, prior to the enactment of the Fair Housing Act, and suddenly there's, more protests, and, Congress is facing a new urgency to kind of resolve the unrest that they're seeing. And so, just a week later, they signed the Fair Housing Act into law. So, I think it's important to think about how, we right now historically are in a moment where we have been seeing in the news more attention paid to the, discriminatory policing that's happening. We've had, horrible incidents of racial violence recently, and, in some instances, protests erupting around those incidents. And, this all happened recently. And shortly after some of the incidents on this slide, the Supreme Court had to decide an important issue under the Fair Housing Act. And this was maybe the first Supreme Court decision in decades, the Fair Housing Act, in which the court was considering whether, does the Fair Housing Act prohibit housing providers or people in the business of providing, any kind of housing from enacting neutral policies that weren't adopted with a discriminatory purpose, but that nonetheless had a discriminatory impact. And the court held that it did. And in going through the decision, Justice Kennedy outlines the history that I just provided you, and points out, the purpose of the Fair Housing Act is to integrate neighborhoods, to provide housing choice, and to eliminate the harms of segregation. So there's essentially a public safety element there, and that's not possible if we just ban intentional discrimination. We have to look at broader policies that impact members of protected classes, to make sure that the harms of segregation don't continue. So the Fair Housing Act at its core provides two theories of liability. One is, as we all know, intentional discrimination, and the second is disparate impact. So, just to repeat that, not only is it illegal to treat people differently on the basis of their membership of a protected class, but, policies that have a disparate impact also violate the Fair Housing Act, whether or not there was discriminatory intent. And the Supreme Court opinion that I just mentioned was called Texas Department of Housing Community Affairs versus Inclusive Communities Project. So it's important to think about disparate impact because criminal background screening policies often implicate disparate impact liability, and they sometimes implicate differential treatment as well. Under both those policies, it's unlawful to intentionally discriminate or have a policy that affects a specific protected class of people. The Fair Housing Act defined 7 specific protected classes: race, color, national origin, religion, sex, familial status, and disability. And I'll just point out that familial status means living with somebody under the age of 18, or having a child, adopting one, etc. And being disabled includes having a prior addiction to a controlled dangerous substance, or presently suffering for alcoholism. Both of those things do come up in the context of criminal backgrounds. So, just backing up, you will notice that the criminal background isn't a protected class here, right? The Fair Housing Act, does not prohibit housing providers from considering criminal records, but it does prohibit using criminal record screening policies as a pretext for discrimination. Basically using the criminal record as an excuse to make a decision on the basis of somebody's protected class. And it also prohibits using criminal record screening policies in a way that causes an unjustified discriminatory effect on a protected group. So, who is disproportionately impacted by criminal background screening policies? Well, often this, depends on your community. It's pretty safe to say that, nationally and probably in most communities, African Americans and Latinos are disproportionately subject, to these procedures and impacted by them. And you have to keep in mind that this is the result of the fact that they are disproportionately subject to interactions with the criminal justice system. Look at all of the work that is being done in reforming the criminal justice system today, and on there is a greater understanding that the criminal justice system itself has systemic problems and racism involved in it. So the fact that African Americans and Latinos are more likely to have criminal records is often a byproduct of this, kind of broken and long discriminatory system. So restrictions on housing ex-offenders disproportionately excludes African Americans and Latinos from housing opportunities, and I'm going to give you a couple of statistics here. So nationwide, 40% of prisoners are African American, compared to 13% of the total population. In Louisiana, this is even worse. Louisiana, 66% of prisoners are African American, compared to 32% of the population. 60% of African American men in New Orleans have been arrested. Think of that, 60%. So if you have a policy that excludes people from being arrested, you are going to just by default exclude 60% of African American men if you are in New Orleans from your housing. 43% of African American men in New Orleans have been convicted of a crime. Every year, I think something like 600,000 people are released from prison nationally, and about 11.4 million are cycling in and out of local jails. It's a significant amount of people. So, the effects of this are that, people with criminal records face, I think we all know this, considerable barriers when trying to put their mistakes behind them and reintegrate into society, and housing is often one of them. The irony is that finding housing is critical to successful reentry in society, and that studies show that the risk of further incarceration is dramatically decreased when folks are housed. So housing not only helps somebody who has had a criminal conviction, come back into society and have happy, healthy, successful lives, but it also makes communities safer because it reduces recidivism. And HUD has recognized this. And as a result, in April, knowing that there are significant barriers that people with criminal records face, HUD released guidance on the use of criminal records in screening policies. This guidance applies to anyone who provides housing or that is engaged in real estate related transactions. So it's important to note, you don't have to be involved in a HUD funded program for this policy to apply to you. If you are a housing provider, the concepts in this policy are relevant to your work and to your practices. The guidance applies not only to everybody kind of in housing, but it also applies to the use of criminal records, in kind of any context. So not just, if you are screening somebody to who's applying to live in your unit, but also if you have other policies, including maybe eviction policies. If you have any practice that considers criminal history, this guidance applies. Now, there are a few things to note that this guidance does and does not do. This guidance does not change the fact that criminal background is not a protected class. It also doesn't prohibit housing providers from considering criminal history when making housing decisions. But what it does do is it explains how those kind of standards of proof that I briefly mentioned earlier in terms of intentional discrimination and disparate impact apply, when a housing provider is using criminal history screening policies, or using criminal histories in really any kind of decision. So, this isn't creating anything new for anybody. This is not a new standard. It's just explaining how existing standards apply in the context of criminal screening policies. I think this right here is the kind of crux of a policy, and maybe one of the most important paragraphs. The HUD guidance says that a housing provider violates the Fair Housing Act when the provider's policy or practice has an unjustified discriminatory effect, even when the provider had no intention to discriminate. Under the standard, a facially neutral policy or practice that has a discriminatory effect violates the Act if it is not supported by a legally sufficient justification. Thus, where a policy or practice that restricts access to housing on the basis of criminal history has a disparate impact on individuals of a particular race, national origin, or other protected class, such policy or practice is unlawful under the Fair Housing Act if it is not necessary to serve a substantial, legitimate, non-discriminatory interest of the housing provider, or if such interest could be served by another practice that has a less discriminatory effect. Now, I understand that's a kind of a mouthful, so let's break it down for you. Disparate effects, any facially neutral policy or practice that disproportionately excludes members of one or more protected classes, if it is not supported by a legally sufficient justification, will violate the Fair Housing Act. Okay, so what does that mean? Well, first of all, it does not mean that any policy that has a disparate impact on a particular class automatically violates the Fair Housing Act. It does not mean that. A policy is only illegal if it lacks a sufficient justification, and if there is no narrower alternative. So, there's kind of a three-step burden shifting analysis that applies. I guess burden shifting is lawyer talk for who has to prove what. But the crux of it is that, the first thing that has to happen when alleging and establishing that a criminal background policy is discriminatory in the Fair Housing Act is that the plaintiff has to show that the policy has a discriminatory effect on protected classes. This often requires statistical showing, but as we talked earlier, the statistics are pretty stark. This is not a particularly hard burden, I think, in this context to show that a particular criminal background screening policy is going to have a disparate impact on people of color. But once, and as we talked earlier, African Americans, I think, are arrested more than double of their proportion of the general population. They are incarcerated more than 3 times of their proportion of the general population. Similarly, like when you look at the Latino population, their imprisonment rate is more than twice of their proportion of the population, and African Americans are jailed more than 6 times their proportion of the population. That national data suggests that criminal record policies are likely to have an impact on race and national origin. Once a complainant shows that, then the respondent has to establish that there's a substantial, legitimate, non-discriminatory interest served by the policy. This is important. It has to be a legitimate interest. It can't be something made up. It's got to be a real concern. And it can't rely on generalizations, speculation, or stereotypes about people with criminal records. I think a lot of people assume, oh, well, if you've been convicted of something in the past, you're more likely to do it again. Well, that's not necessarily true. Your justification needs to be supported by evidence that shows this. In order for your policy to pass muster under the Fair Housing Act, under the Disparate Impact Test, you need to be prepared to show that your policy is tailored to your specific needs of finding suitable tenants. That means, is your policy accurately distinguishing between individuals who pose an unacceptable risk and those who don't? HUD in its guidance does not say, what policies will, pass this test. But it gives some strong statements that policies that don't consider the nature or the severity of criminal contact, that don't look at how long ago the conduct occurred, are not likely to meet the standard and be narrowly tailored enough. So, even if you show that you have a legitimate interest, then the burden shifts back to the complainant to show that there are, maybe perhaps a less discriminatory alternative that can satisfy your interests, say it's safety, but is going to impact people less dramatically. So like I said, HUD doesn't prescribe a particular policy in its guidance. However, it does note two areas where a policy is just plain unjustifiable. One is criminal screening policies that exclude people on the basis of arrests. HUD has plainly stated that an arrest is not evidence of criminal activity that can support an adverse admission, termination, or eviction decision. Arrest means nothing. It means that somebody suspected you of a crime. It doesn't mean you did it. Therefore, it's not probative. It's not relevant. The second thing that HUD draws attention to are what we call blanket bans or total bans. Bans that categorically exclude people on the basis of their criminal history, or categorically exclude a category of conviction. A ban that does not consider when the conduct occurred, what it entailed, and what the person has done since then, will be unable to meet this burden. So, you have to look at your applicants and consider, how old were they when they engage in the criminal activity? How old are they now? What has changed in their lives? Was the conduct something where, were they just kind of in the wrong place at the wrong time, and young, or those are the kinds of things that you need to think about when deciding to exclude someone. So, HUD believes that, an individualized assessment rather than categorical exclusions are going to do a better job of considering, somebody's risk to the community. So, just the key considerations to consider, I mentioned the circumstances, the severity of the crime. You should look at, how long ago the conviction happened, how old you were, how often somebody maybe was convicted. Frequent convictions might be more relevant, evidence of rehabilitation, and also like maintenance of like your tenant history. Was your applicant a good tenant before the conviction? Have they been a good tenant after the conviction? All of these are going to more accurately distinguish between those that pose an unacceptable risk and those who don't. So, in addition to disparate impact, the guidance also specifies that the Fair Housing Act is violated when housing providers intentionally treat individuals with comparable criminal records differently because of their membership of a protected class. There have been cases out there when a housing provider had, inconsistently used a criminal background policy in order to purposely keep somebody out because of their, race or national origin. So in New Orleans, we kind of became interested in this issue when a client of ours had, I think she had called and had inquired about the criminal background policy, and because her daughter had a misdemeanor on her record, and she was told that only felony convictions would keep you out of the complex. Well, then when she went to apply and she showed up, and she's Black, and the housing provider seeing that, she's denied because of her daughter's misdemeanor conviction, and that let us ask, how often are housing providers doing this? So we did an investigation. Now, this was not a report on disparate impact, but rather an investigation to whether criminal background screening policies were being used as a pretext for racial discrimination, where we sent out, black and white testers who had comparable criminal backgrounds, and to see, how are they being treated. And over 50% of the time, African American testers face discrimination. And that actually was increased if the policy was really unclear and ambiguous or discretionary. So, how do people discriminate intentionally? Well, they would provide the African American testers with inconsistent information about their background policies. They would coach white testers on how to appeal a negative admission decision, and they would make exceptions to their policies for the white testers. We had one housing provider say, you know what, to the white tester, we've all been young, we've all been there. And, completely waived the criminal background policy altogether for the white tester, but did not do the same for the African American tester. As many people know, sometimes applying for housing, can be expensive. There's an application fee, and some providers would be asked, hey, listen, I have this conviction on my record and I want to apply, but I don't want to pay the $50 if I know that I'm going to be rejected on the basis of my criminal record. Often the providers would waive the application fee for the white testers or the criminal backgrounds, but not the African American testers. Or they would do other things by, like, doing more research and trying to figure out whether or not they would be rejected before having them apply. So they would kind of, let me tell the white tester, let me look into this for you, and they would call their supervisor or go up the chain to really get more clarity on what their policy was and provide the white tester with that information to enable the white tester to have, to decide whether or not they wanted to go through the process. But with African American testers, they would not give the same kind of customer service, so to speak. So, interestingly, there were a lot of policies out there that were discretionary, like, oh, we do this case by case, or we, we'll decide on how we feel. If we think that you might be a risk, we'll run your background. Well, in those cases, even more discrimination and bias creeped in by the rental agents, and the rate of discrimination increased to 55%. So what are some takeaways from all this? Here are a list of some screening policies, do's and don'ts, and I actually want to do a shout out to the National Realtors Association, who put together a list that some of this is taken from, and did a relatively good job. So, it's important that you tailor your criminal background policies narrowly, that you have specific reasons for them, that you have evidence that shows why you are enacting a particular policy. It's important that you consider, what we talked about before, the nature and severity of the conviction, amount of time, etc. There's a couple of things that I also want to point out here, though. A good practice as a provider is to provide individuals with a copy of their criminal history report and give them the opportunity to dispute any inaccuracies before making a housing decision. There's a lot of credit reporting, criminal history reporting places out there, and they come back with inaccurate information. Those history reports can be really hard to read, and many leasing agents can't tell what's an arrest and what's a conviction. There's been a lot of litigation around inaccurate reports from these background services. It's also important to have a clear process for how you're going to consider your criminal backgrounds, that everybody is treated the same, so you avoid treating people differently. You should make your criminal background policy available to anyone who's denied on the basis of criminal history, so they fully understand what has happened and what your policy is, so you can avoid concerns that this was unequal treatment on the basis of race. Importantly, I think training rental agents carefully to make sure that they really understand the policy and processes is going to protect against their, whether intentional or not, racial biases coming through. I think during our audit, one thing that we've learned is that a lot of the agents who, don't understand the policy, and so that's where we would start getting, more work to try to figure out what it is for the white tester and not the black tester. And I think that would have been avoided, frankly, if some of these agents had better training about what the policies and processes were. Some things to note about what you should do is, let me go back. Sorry, excuse me. One other thing to point out is that it's important that when you create your policy that you're not kind of like relying on your criminal background check service to create your policy for you. I think we see a lot of landlords who will tell a renter, well, if it comes back, then you're excluded. But they don't really understand what it is, and they're just applying, if it shows up on the report, they exclude them. Well, there's no legitimate reason for doing that. If you don't understand what your policy is, you don't have a legitimate reason for the policy. Other things that is very clear is that you should not be creating exclusions based on arrest records, and you shouldn't be adopting blanket bans. So, in New Orleans, we spent a lot of work working with our local housing authority to come up with a policy that we could get behind, the community could get behind. That served the HANO's interests, but also was narrowly tailored to those interests. So HANO had a policy in the past that would consider arrests that really had no defined length of time that it was looking back. So people were being denied access to public housing based on arrests or convictions that were years and years old. So we began working with community organizations, HANO clients, and another organization called the Fair Institute for Justice, which does a lot of work on criminal justice reform to advocate for the change in those criminal background screening policies. And the new policy does a couple things. It removes any presumption that an applicant with a criminal background should be denied housing. And it calls for this two-tiered process. The first tier is you look at the screening grid that kind of defines what crimes and what look-back periods are potentially problematic. And if you're in that grid, then it provides a process of further review where you do an individualized assessment. So here's an example of the grid. You see that there's crime categories, assault and battery, subcategories for review. So in HANO, if you have an assault on your record and it's a felony, if that felony is within 3 years of the conviction or 1 year of release, then you're not automatically denied. You just move on to the next level, which is further review, where you have an opportunity to provide, evidence of your rehabilitation, where HANO will look at these other factors that we talked about earlier, like the underlying conduct and that kind of thing. But if you were convicted of assault and battery and it was a misdemeanor, well, you're not on this grid, so you are going to be admitted. I mean, assuming you're eligible under other criteria, but the criminal background will not be a barrier for you. Or if you had assault and battery and felony, but it was 7 years ago, you will be admitted. So this grid is only about whether or not you go on to further review, and after further review, a final decision is made. So the further review at HANO involved putting together a review panel, which are members chosen by HANO. And the panel has a current resident with a criminal background on it right now. And the further review under HANO's policy has to consider things like, the history we talked about before, but also, rehabilitation, whether they've received treatment, what's going on in the community, do they have community ties, what's their support situation, are they working, other things that will help understand whether or not they are a risk. And one thing I should just point out back here in the screening guidelines, that these categories and timelines were done with the work of the Fair Institute and based on research of the likelihood of repeat offending. So, based on that research, at least in Louisiana, the risk of repeat of recidivism, of doing the crime again, dramatically decreases after these time periods in this right-hand column. And the only other thing I should mention that the subcategories of felony versus misdemeanor, that is based on Louisiana law, so your community might have different subcategories. Okay, I just wanted to quickly, I think we're getting close to the end, I wanted to quickly just mention another area of the fair housing law that also comes into play when you're looking at criminal screening policies. Under the law, the Fair Housing Act requires housing providers to make reasonable and necessary accommodations for people with disabilities. So basically, if somebody with a disability says, hey, you have this rule, and this rule is acting as a barrier for me to live here, can you please make an exception to that rule as a housing provider, so long as that request is reasonable and necessary, you have to provide it, you have to grant it. So this comes in a lot, I think, in the context of criminal background screening policies, because the definition of disability, as I mentioned earlier, does include recovering from drug addiction. You might be faced with an instance where you're that conviction, is a result of an addiction issue that the person has since recovered from. And so the reasonable accommodation might be another area where the law requires housing providers to make exceptions to their criminal history policies. And as I mentioned earlier, these policies and HUD's guidance, doesn't only concern admissions policies, but it also concerns, any other housing policy, and that includes, what people often call zero tolerance for crime policies in housing. These policies, have been shown to have a disparate impact on women. And so let's just kind of talk about that for 1 minute. There was litigation, gosh, a number of years back in HUD where housing provider had a zero tolerance against violence policy in which all members of a household, all members, so that includes the victims, would be evicted if there was any violence in the apartment. And what happened was this young woman was, brutally assaulted by her husband in her home. And within 24 hours of that assault, she received an eviction notice. And this was despite the fact that her husband was arrested and she had gone and received a restraining order. So he was not, he was out of the picture. And, the landlord issues her this notice that said, either the tenant or someone in the tenant's control has inflicted substantial personal injury. They're talking about the injury that she had had to evict her. A complaint was filed with HUD, and during the HUD process, investigators gathered statistical evidence to support a charge of discrimination, basically on a disparate impact theory. They found that, this policy of evicting innocent victims of domestic violence had a disparate impact on women. And as a result, the tenant had been discriminated against because of her sex. Zero tolerance policies, if you look nationwide at the statistics, they have, a disparate impact on women, and particularly African American women. Women are the overwhelming majority of victims of domestic violence. The USDOJ has a study that found that 85% of victims of intimate partner violence were women, and up to 50% of homeless women and children in the United States are fleeing domestic violence. So that is something to consider when you're doing a zero tolerance policy. You want to think, how can you narrowly tailor it to be sure that it's really accurately addressing the risk that you're trying to prevent? What proof are you requiring that the person engaged in the activity? Why are you requiring that the person be evicted, why are you evicting somebody who's related to the person who did the conduct, and if so, why? What's the rationale for there? And I would consider that, when you're crafting these policies. So I think we now have some time for some questions. Here's my contact information. You can always feel free to reach out to me, if you have any questions, and I'm happy to do my best to answer them.
Thank you, Elizabeth. You've given us a lot of great information here. I want to let attendees know that this webinar was recorded and will be available to all attendees after today. So if you wanted to look back at some of the information that Elizabeth gave us today, you will be able to access that. And I also want to remind you that the HANO guidelines that she was referencing are in the handout panel there. You can also find them on our website, the fhcmichigan.org. We do have a few minutes for Q&A. I have a couple questions, but mostly comments coming in. So if anyone has any questions, we do have a few more minutes. If not, I'm going to put back on. My contact information here. If we have no questions, I just want to say thank you again, Elizabeth. That was really great. I hope that everyone found this webinar useful for your work, and thank you again for joining us today. And if we have no questions, and then thank you, and that will end today's presentation on fair housing and tenant selection. Thank you so much.